So, you know you need to make a will, you're aware that there's a DIY option available, but how do you know it's the right option for you? Today, we're exploring the problem with DIY wills. Problem number one, you don't know what you don't know. So, you make this will to provide peace of mind, knowing that your estate will be distributed to your beneficiaries in accordance with your wishes. A will is only looked at after someone dies. So if there is a problem with something you've written or the way that you've written it, it won't be discovered until after you've died, and therefore it's too late to rectify. Another problem with DIY wills is sometimes the testator, the person making the will, forgets to sign it. I know you would think that I'm making this up, but I promise you, I've seen this on numerous occasions. The will itself is fine, the words are fine, but the person who's written that will has just simply not signed the will, and it's invalid. Another problem with DIY wills is where the will fails to dispose of everything that's owned when someone dies. So when you write a will, people are usually really good at listing out all of their assets. They'll tell you that they've got a car, they've got some jewellery, they own a house, they own a painting, and they've got a bank account. Great. And often DIY wills list these things because they want to send different assets that they have to different beneficiaries. And that's okay. But what a will really needs is a residual clause, because we don't know when we're going to die, because we don't have a crystal ball. And when we die, we might own different assets. They might be similar to the ones we've left in the will. They could be completely different. But what you need is a catch-all phrase in there, catch-all clause that will deal with everything else that I own when I die. And often DIY wills just don't have that in. The consequence of this is the will itself is valid, but you die partially intestate because not all of your estate can be distributed in the terms of the will that you've written down. Another problem with DIY wills is witnessing. So what can go wrong with witnessing? A few things. For a will to be valid in the UK, it must be signed first by the testator in the presence of two independent witnesses, both together at the same time. So 3 people in a room together. Often we see DIY wills that are either not witnessed at all, so it's invalid, witnessed by one person, therefore it's invalid. Sometimes we see them where it's been witnessed by 2 people. So on the surface, it looks absolutely fine. But if those witnesses weren't together at the same time that the testator signed the will, it could be a problem later on. And you might be thinking, well, how would anyone know? Well, with DIY wills, often the probate registry need or require an affidavit statement from each of the witnesses swearing the terms that the will was signed. So really confirming that, yes, the will was signed by the testator, 2 witnesses present. The affidavit statement to a normal person looks quite scary. It's a legal declaration. You are swearing that the information given is wholly correct, and any misinformation or wrong information that you give is unlawful. So sometimes people don't always respond to these affidavit statements, or the will was signed so many years ago that the witnesses can't be tracked down, or the witnesses themselves have died. This can be a huge problem, and wills will get rejected by the probate registry. Another problem with DIY wills is, and I've seen this one a few times, is where a witness is also a beneficiary. So under UK law, if you leave beneficiaries in your will, the rule of thumb is a beneficiary cannot be a witness. And it goes wider than that. The spouse or a closely connected person of that beneficiary cannot be a witness. So let's say that you've left your car, your classic car, to one of your friends, but your friend's husband has signed as a witness. So that gift is going to fail. It can have far wider consequences. So if your main beneficiary of your estate, so one of the residual beneficiaries, so a portion of your estate is going to go to this person, if their spouse or partner has signed to be a witness in the will, then that gift is going to fail. And therefore, what you intended to happen often doesn't happen. Another problem with DIY wills is that the testator fails to sign the will. I know, you can't believe it. I often see this and I can't quite believe it either. How can you have a legal document that looks perfectly fine, and it's been witnessed actually, but it's not been signed by the testator? It's going to fail. That will is going to be invalid. Another problem with DIY wills is lack of contingency, lack of future or forward planning. So the will might appoint an executor, which might be your spouse, and the will might leave the whole estate to the spouse, which is fine. But what if your spouse dies before you? Where's the contingency? So if you've not put, if my spouse dies, I appoint my best friend to be my executor, then you've died partially intestate because the executors aren't correct. But more importantly, on the residual estate, if you've left your estate to one person, but they've died before you or at the same time as you, where does the estate get distributed then? If there's no contingency in your will, which is often the case with DIY wills, the will is going to be invalid and you will die intestate. Another problem with DIY wills is the fact that they offer little or no protection to future events that can't quite be predicted at the time that you write your will. So I'll give you an example. We have a married couple. They think their situation's really simple. They want to leave their whole estate to each other, no problem. And then when they're both not here, they want their estate to go to their children. Sounds simple. But what if person A dies, leaving everything to person B? Person B then remarries or needs to go into long-term care. The whole estate is then at risk either in that new marriage or care costs. There's no protection in the will at all for those ultimate beneficiaries, and people don't always realise that. I'm Ali from Heritage Estate Planning. I hope this video has been really helpful for you, giving you enough information to make the right choice for you. If you'd like some professional help or advice, myself and my team would be delighted to help you. Head over to our website, www.heritageestateplanning.co.uk, for helpful guides and to book your consultation meeting. Thanks for watching.